Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about fraudulent court orders. Cases that should have gone to the Supreme Court of Canada, but didn't. In a family law proceeding in British Columbia, a consent order was reached between two members of the family. That consent order was filed in court, it was signed by a judge, and the order was granted. In unrelated proceedings, that same individual who sought the consent order and was granted the terms that they wanted provided evidence that was ultimately determined to indicate that she had committed some fraud in relation to her income and financial assets. And as a result of determinations in the unrelated case, where those admissions had been made, a judge sought to undo the court order, the consent order that had been granted. Even though both parties had agreed to the terms of the consent order, and even though both parties in the case did not want the order to be undone, the court nevertheless undid the court order on the basis that a fraud had been perpetuated on the court. Leave was sought to the Supreme Court of Canada after unsuccessful appeals, and leave was denied. And this case does raise very important issues because, of course, courts should be wary of anything that even approaches a potential fraud on the court. But consent orders are in a different category on their own. Much like the Supreme Court of Canada has commented on joint submissions in criminal proceedings, which give individuals certainty of what is likely the outcome of their criminal pleas and the outcome of their cases, consent orders give individuals in civil proceedings confidence that something is going to be resolved in a way that is mutually agreeable to the parties. And even though there may have been some fraud that had occurred in relation to the proceedings, one has to assume that when both parties are aware of the circumstances and still tell the court, we think this order is still justified, that regardless of the fraud, their position would not have changed. And there was no suggestion in this case that the second party was complicit to the fraud, such that they would have benefited from the fraud of this individual, because they were on opposite sides and because in family law proceedings, income and financial assets really determine a lot of the cases. So why does the court need to interfere if the fraud appears to be, to a large extent, unrelated to anything that would have happened in court? And the result of this, of course, is also to complicate additional proceedings, because now no longer can a consent order be reached on the basis of what the parties have agreed to. Now the matter has to be heard at trial. And one of the parties is at a disadvantage in a trial or in an application in relation to this because of the other findings in relation to fraud. Ultimately, the Supreme Court of Canada, I think, really missed the significance of the consent order and its likeness to a joint submission. And so long as it wasn't obtained as a result of a mutual fraud, if both parties are aware of what had happened and still agree that this is the just outcome, then that really should be the outcome that the court goes along with it. The court could issue brief reasons explaining this and criticizing the parties for engaging in fraudulent behavior, but they don't need to rescind an order and put everybody back to step one, particularly in family law proceedings where significant financial assets, banking decisions, and children can be involved and where other innocent, unrelated people can be affected by these decisions. Ultimately, the Supreme Court of Canada had the opportunity to really create a framework as to how consent orders can be assessed and revisited in a way that aligns with what they've said about joint submissions in criminal cases and make the efficient delivery of justice in cases a lot more clear. Hopefully, the Supreme Court of Canada hears a case like this again and provides some very clear guidelines for circumstances like this. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.